So the news is that the global e-commerce technology company Amazon is expanding to Nigeria and South Africa. Now this is really exciting because this is going to give other existing e-commerce platforms probably just sit up and start doing things a lot better. But our storyline or case study for today, it's actually a case that features Amazon, and it's like an interplay of intellectual property and e-commerce, how e-commerce company can position themselves in a digital era, and what are the liabilities in the event of an infringement where a pirated or an infringing product has been sold on e-commerce platform like Amazon. Because I don't think Jumia and Konga has experienced things like this, but I've seen a couple of cases where people who subscribe to either eBay or Amazon to sell products or on the platform end up being accused of one thing or the other, and then Amazon is roped in the dispute. So what are those things that e-commerce platforms like Amazon need to look out for while setting up their businesses in Nigeria, and how to deal with trademark infringements or intellectual property infringement, as the case might be. Now, where are my manners? Welcome, guys, to today's episode. I think this is the 70th episode. Oh my gosh. So welcome to the 70th episode of IP series with your favorite podcast host, Rita Chinda. Now we talk about recent cases and developments globally with regards to copyright, trademark, patent, industrial design, trade secret, plant variety, and geographical indication. So if this is your first time listening to my podcast, thank you. Don't forget to hit the subscribe, the follow, favorite, whichever platform you're listening on. Don't forget to subscribe. And for my returning listeners, oh my God, you guys are the best. I mean, thank you for always coming back to listen to me talk about intellectual property. And yeah, don't forget to also share with your friends and contact and family. And with that, we're going right into today's story. If there's one thing that we can take away from the pandemic, is the fact that technology made things a bit easier for us. With tech, it was easy for you to just sit at home and place your orders and you got your stuff. Now, e-commerce, more than any other platform, involves the selling of goods and services that have intellectual property rights. So a good could have a name, a logo, a sign, design, the product itself, the packaging. And it's very important that platforms like e-commerce take IP serious in order to protect their business interests. They can also help the business in branding. They can also commercialize elements of their businesses. They can also consider policies such as return policies, privacy policies, cookie policies, whatever thing they are doing. Just take all of that into consideration for you to have good elements or strategies for your company, and also comply with the regulatory requirements in the jurisdiction that you are going to be starting up your business. So what are those things that Amazon needs to do? Setting up or expanding to Nigeria. So other than intellectual property, they also be talking of industry compliance, tax, etc. Now, in today's case study, the case is between David of licensee Coty against Amazon. This decision was given in 2019 by the Court of Justice of the EU. Now, in this case, the the Court of Justice of the EU on the 28th of November 2020 said that companies like Amazon cannot escape trademark infringement simply because They are not the seller and could be held for failing to exercise a certain degree of diligence in detecting counterfeit and other infringement from third-party sellers. So, why Amazon is coming into Nigeria, what are those policies that they've put in place to protect themselves from liabilities or disputes that consumers may want to exercise their right in terms of suing, where they've been cheated or defrauded or scammed, like we like to say. I mean, if you've been scammed by an Instagram seller, you would definitely understand what the implications are for e-commerce platforms like Amazon and why it's very important to get it right. Now, this case began sometime in 2017, where the EU Court of Justice had held that e-commerce platforms such as eBay and Amazon can block retailers from selling their products on their platform, especially if the person has been notorious for selling counterfeited products. They would take that step to protect themselves. Now, I first came across this publication when it was posted by at Fashion Law. You guys check out the blog if you're interested in fashion law. This is a blog curated especially for fashion related disputes. They're both on LinkedIn and on Twitter. So now, if this was in Nigeria, are courts ready to fight infringement in the digital age, whereby the person infringing, the third party infringing, did not even get like a license to sell, but they decided to put up that product online and resell it? When will our law be at par with the reality of intellectual property in the digital age, and when will we have like an IP policy that helps protect creators and innovators while helping the country's economy to grow? Is there really enough sensitization and awareness on the role of intellectual property in the economy? Because globally, we are considered to be like least developed country. So yeah, those are like some of the matters arising. But we just I'll just take us through what e-commerce is and how it interplays with IP, and then I'll focus on the case between David Off, licensee Coty, and Amazon. So e-commerce is defined by Shopify to be activities related to buying and selling of goods, and also service using the internet and the transfer of money and data to execute this transaction electronically. I mean, this involves a lot of things. So you're talking about fintech, data protection, because you're going to be exchanging data, like giving out your informations to the platforms, and then the e portal will do is business. Now, this can occur for a B2B business or B2C or C2C or C2B. Now, top e-commerce websites in Nigeria as at 2019 included Konga, Jumia, OLX Nigeria, PayPod, VConnect Nigeria, Kara, Printivo Store, Udala, Deal Day, Mobile Free, Slot, etc. But presently, I'm sure we have a lot more. Now, from the list that I listed above, Udala and Konga became a merger in 2018. Yeah. Now, one of the component was that the companies consider was their intellectual property, because when you're doing mergers between two companies, you have to consider which one has a bigger presence and which one has more reach, while at the same time you're combining your reach and gaining new consumers and new markets and the rest of them. Now, role of intellectual property in commerce. Internet usage for e-commerce and the proper usage of the tools of intellectual property system is important for the development of a digital economy and the success of the e-commerce company. Two things to keep in mind: you need to safeguard and protect your intellectual property, and make sure that you're not actually infringing or violating another person's intellectual property rights or intellectual property. And this makes e-commerce platforms like Amazon depend on companies working together to share what they have through a licensing arrangement, or considering the opportunities and the risks of business. An e-commerce based business usually hold a great deal of value when dealing with intellectual property, which could either make or break any IP valuation. So in the event that they decide to go into a merger such as the one that Udala and Conga did, an IP valuation will be very necessary for the company, as they will go through the inventory of the company's intellectual property or intangible assets, review contracts that may affect the company assets, while considering an IP or intellectual property audit to review their intellectual property, what the company has, while verifying their intellectual property, what to protect, what to exploit, what to grow. And it's also best that while doing all of this, you're speaking with your intellectual property lawyer. Now, the relevant form of intellectual property relevant to the e-commerce platform includes copyright, trademark, patent, industrial design, and trade secret. Now, our case study for today is focused on trademark infringement, but I'll just do like a brief rundown of what the other IPs are all about. Copyright, as we know, protects original literary and artistic creations of all types, such as composers, software developers, web designers, who you will need while building your e-commerce platform. Copyright is the only IP that gives you automatic protection so far as your work is in a fixed or tangible medium or format. It also gives you legal protection and backing, gives you exclusive bundle of rights for a limited period of time, which is like your lifetime plus 70 years afterwards. It also gives you like economic right to control the use of your work for revenue or remuneration. They also have the moral right to prevent any modification and protect your reputation and integrity. It's also important to state that copyright does not protect ideas, titles, slogans, short phrases. So if you have like an e-commerce idea, like, oh, there's this business I want to do, I want to create like an e-commerce platform like Amazon, you're still in the formation stage. You haven't put pen to paper for us to see it in a tangible format and like, oh right. So even if it's highly creative, you can enjoy copyright protection depending on the jurisdiction. Now you get exclusive right for that. You also have the right to reproduce, to make copies, to distribute, to rent it out, to licenses, to do any adaptation or translation, etc., etc. Now, types of copyright that is relevant to e-commerce platforms: computer program, software, design chips, routers and switches, user interface, source code, algorithms, technical descriptions, programs, logic flow charts, and database content. And now I have an episode on IP rights as it relates to UI UX design, so you guys can check out that episode. Then the Google R cookies, is another one that you guys can also check or listen to. Now, if you pay someone to develop your website, who do you think actually owns the copyright? Now, this depends on two things. One, what the law provides in Nigeria is that the first person is the author. However, in the event where you were hired or commissioned to do the work, or you made it while you built the website or the platform while you were an employee, an agreement is what would determine who owns the work. And also, there's also you can also go into like joint authorship or ownership where several persons contributed to the work, and then also consider if it's a derivative work, but it may not really apply here. So what's the difference between authorship and ownership? Now, authorship is the person, or an author is the person who created the work, while the owner is the person who like merely contributed information or ideas or suggestions, but did not contribute to the expression of the work, and therefore has an exclusive right to explore the work. So I hope that actually makes sense. Now let's go to the next form of IP. Next type of IP is patent. And patent would be the invention that relates to the software that was used to build the e-commerce websites and the internet text. Now, any software that demonstrates control or configures some company's hardware can be patented, regardless of whether it includes significant mathematical process, and that is like the guideline for registering software patents in the United States. Next on the list is trademark. Now, remember I had stated that our case study for today is a trademark infringement case, but I just want to go through the types of IP and how relevant they are to the e-commerce. So next up is trademark and unfair competition in e-commerce, which will include goodwill, reputation, logo, the symbol, branding, customer recognition of the e-commerce platform. So example, I already listed out types of e-commerce brands in Nigeria already, which Konga, OLX, Dilde, etc. And now with Amazon coming in, so we put Amazon in the list as well. Trademark is very essential for e-commerce business as it helps with branding, customer recognition, goodwill. They're also essential elements of a web-based business, which are protected by trademark and unfair competition law. Now, e-commerce business owners should avoid using a trademark in a way that it will cause confusion. So once there's a likelihood of confusion in the space, that's going to raise some issue, because trademarks acts as a source of origin to a product. Trademark infringement in digital age and how it's related to e-commerce will include meta tagging, AdWords, cyber squatting, domain name issues. Now, I'll explain each of these types of trademark infringement. One, which is meta tagging. This is where you use like keywords or phrases and you put them in your website's HTML code, and they are visible to people that want to access your website, but they cannot be read by some search engines by placing names of competing companies in the meta. For example, we had the case of cosmetics warriors against Amazon again. The claim was that Amazon breached the lost trademark in a number of ways, and that Amazon UK and EU arms were joint tortfeasor in that case. Now, what that means is that each was a party to a common design to infringe their trademark. One head of the claim concerned internet advertising. Amazon had bid on the keyword lush. Okay, let me just continue. So sometimes you may be doing like a Google search, you want to access something, and then you put in word. And because they have inputted these meta tags where some keywords will lead you straight to their website, you end up not going to the original site that you want to go to, but you're being diverted. So Google had used the keyword lush within their Google AdWords service so as to trigger a sponsored link advertisement appearing on the Google search results. Whenever a customer types lush into the search box, Amazon will be part of the search list. Now, another case is the Interflora against Marks and Spencer case. It's also a UK case. Now, the UK High Court decision related to keywords and trademark infringement has stated that there was a need to balance and protect trademarks with reputation and fair competition in the sector of goods and services. The court also said that the use of a sign by an advertiser as a keyword to trigger a sponsor link in use in the course of trade that relates to the advertiser's goods or services, even when the sign selected as a keyword does not appear in the advertisements, that such use can be prevented by the trademark owner if it is liable to have severe effect on one of the functions of the trademark, which will include that trademark identifies the commercial or trade origin of the goods which is applied. The second would be which basically is like a badge of origin. The second one would be that it advertises the goods or services sold by the trader in connection with the mark, which is known as the investment vehicle. And thirdly, it can be an indication of quality, which helps in differentiating between inferior goods. So back to our conversation where third-party sellers, try to make consumers or the buyer feel that what they are buying is actually the original and not the inferior goods. Now, the following elements can be found or protected as an industrial design in the e-commerce business. One, web page, the features of the computers and the icons in the computer. And industrial design as a form of intellectual property, appearance matters a lot. as it can also help a business win brand loyalty. It can also um, stem from a product being new or novel, original, and has its own original or individual character. Registration may be done in a particular class, but it's not limited to the goods in that class of goods. For you to get an industrial design registration, it helps in improving on competitiveness in the following ways. One, registration means that you obtain a fair return of investment. You also see it as a business asset which can be licensed and it can contribute to the total revenue of the e-commerce business. It covers unintentional infringement, and the registration certificate is an important proof in the case of an infringement. Now, once a design acquires distinctiveness through its use in the market, over a period of time, it qualified for being registered as a mark. Next up is patent. Now, in the US, you know that the US Patent and Trademark Office has the right, and this software patent application guideline was issued in 1996. We are trying, Nigeria, we are trying, because I know now we have new patent developments in the patent registry where you are allowed to do like utility model registration and the rest of them. So we're coming up. What we just need next is for our laws to be updated. But then, patent registration protection will include protection of the source code of the computer software or anything that has commercial value and gives your business an edge over another business, which includes products, formulas, customer. Now, I'm talking about trade secret because I'm done with patent. But just to emphasize that patent protects new or novel inventions that are not subject to morality or public policy. It also doesn't have to be obvious to a skilled person, and the functionality of your invention, whether it's improving on an already existing invention or it's your new invention, you have to show that in your patent claim. So trade secret is another form of IP that gives you like a business edge over the other So what is making Amazon better than Konga or Jumia? These are things you'll be looking out for. It's also very important that you take precautions about disclosure of your trade secret or confidential information. You also need to make sure that anyone who might get to know about your confidential information, such as your employees or the maintenance contractor, website hosts, internet providers, are bound by a confidentiality or non-disclosure agreement. So yeah, that's about it for the types of IP. Next up, we'll be talking about intellectual property issues bordering on e-commerce and international transaction in the digital era. So our next conversation, what are the issues bordering on e-commerce, international transaction? One will be issues on jurisdiction, because we have different laws that guide and protect intellectual property. And remember that intellectual property is territorial in nature. Other than the intellectual property law, there are other laws that you may need to check out while doing business in that particular area. The next up is enforcement issue, which is one of the issues that arise when dealing with infringement cases, because it sometimes may be difficult for you to actually enforce a judgment or any court order that was given. So next up, types of contracts relevant to e-commerce business. You have employment contract, development agreement, web design agreement, licensing agreement, distribution agreement, domain name, trademark license agreement, cross license agreement, patent licensing agreement, etc. etc. Next up, so I'll just do like a brief summary about the case, what the case is really about, because I'm not sure I've mentioned it, because I just stated that the case is a case between David Off's licensing Coty against Amazon. So in our case study for today, it turns out that Coty, who owns the David Off trademark, found out someone was selling the David Off hot water perfume on Amazon, and so sued Amazon for trademark infringement. Remember, I said trademark infringement is you using someone's work without their consent. Um, and in this case, this will be the product itself, the name, the logo, the brand, everything. Where the brand owner lost because he could not prove that Amazon was aware of the infringement. Now, the court was of the opinion that um, Amazon can be expected to show particular care in terms of control of the lawfulness of the goods they trade in. In essence, what that means is that Amazon has the responsibility to verify the authenticity of product being sold, and that without their control, their platform can be used for the sale of illegal, counterfeited goods, pirated goods, stolen or unwanted goods on their platform. So another brief background about this case is that Coty, Germany, who happens to be a perfume distributor and the licensee of the EU trademark for David Off perfume, sued Amazon for allowing an infringing or a counterfeit hot water David Off perfume to be sold on its platform. Now, Amazon platform allows third parties as owners of intellectual property such as perfumes or accessories or products to actually sell or place offers for sale on their Amazon marketplace section on the website. Now, where that product ends up being sold, there's a contract that states that the goods are concluded between the third party seller and the person buying. Now, those third party sellers must avail themselves to the fulfillment of Amazon's scheme, which allows goods to be stored by the Amazon Group companies and later distributed by external services. Now, when Coty Germany had initially sued Amazon, they lost the case, and it was later brought before the Federal Court of Justice in Germany, and they lost as well. Now, the question then was, would third-party seller whose goods are stored without being aware of that they are infringing someone's intellectual property rights, such as trademark, itself qualifies as an infringement, rather. Let's bring this back home. Let's say, for instance, now I decide to put on sale a Zara shoe or a Zara perfume, and it turns out to not be the original Zara shoe or perfume. Would the buyer then hold Amazon liable? Now, this depends solely on what the terms and conditions were stated on the Amazon platform and what the laws in Nigeria will provide. Now, because this case was taken before the highest court in the EU, which is the Court of Justice EU, they relied on Article 9 sub 2 paragraph B of the Council Regulation EC number 207/2009 of 26 February 2009 on trademark, and Article 9 sub 3 paragraph B of the Regulation 2017/1101 of the EU, that's the European Parliament and the Council of 14th June 27. I'm reading a lot of legal things, but I'm just trying to refer you guys to what was cited and what it said. So what it said was that a person who on behalf of a third party stores goods which infringe trademark rights without being aware of the infringement must be regarded as not stocking those goods in order to offer them or put them in the market for the purpose of this provision if that person does not itself pursue those aims. So basically, Amazon cannot be held liable. But yeah, you guys can check out the law and the podcast version. But you find out that even as e-commerce platform, they kind of have like a warehouse where these goods are stored. Same thing with third-party sellers who may decide to have their own mini warehouse, either at their place of home or exploring the Amazon options and the likes of it. So coming into Nigeria, what can Amazon do differently? Do they put in IP policies that protect them from future dispute? Because the Nigerian market is huge, and you have startups and businesses springing up left, right, center, and we are blessed with really talented people. So with that experience that they've had in jurisdictions like the UK, the EU, what can they do differently that will protect them against third party disputes? What are the online dispute resolution mechanisms that they wish to explore? Would they want to opt for a court resolution option or out of court options? Because with the digital era, more disputes and issues will arise. Again, I think that's another thing that Amazon should consider. Let me know what you guys think. If you think differently, do you think that Amazon should have been held liable for the third party sale that took place on their platform? Were they actually breaching the trademarks of David Off's brand? Should David Off also stop Amazon from storing and delivering their unlicensed products? Is there a way Amazon can curate a list of licensed distributor on their platform, even if they are third party sellers? What are the options available where a consumer finds out that the product they bought was an infringing item? How can Amazon protect themselves? Because as a business, you also have to look at it from the bigger picture, especially now when we have NFTs and the metaverse. What happens if someone decides to curate a product, an unlicensed product, and sell in, let's say for instance, Amazon, and create like a metaverse Nigerian an Amazon metaverse Nigerian market, and someone decides to sell an unlicensed product on that platform? What are those measures or policies that they intend to keep? Would Amazon strictly ban those products? What are the monitoring team going to do? So I think the head of legal should also consider the IP implications for having third-party sellers on the Amazon platform, and they're looking at it from the global perspective as well. How will this benefit the economy, and what are the benefits for sellers, potential sellers in the market? Is there going to be like a blockchain registry for verifying the authenticity of products that will be sold on the platform? So I think Amazon has a lot of work moving into the African space. They can also set precedents for other e-commerce platforms to follow in terms of verifying authentic goods, and checkmating that intellectual property rights of IP owners are not infringed. The international brand owners, and do international brand owners now have to start considering creating or going into distribution agreement or franchise agreement or exclusive arrangements to have selected third-party sellers in Nigeria, or basically using influencers? I mean, the options are huge and enormous. So yeah, we'll be wrapping up in a couple of minutes, but that's all about the summary of the case. So Amazon won against Coty. The court held that they were not infringing. The court had held that they were not really infringing on Coty's rights, that's because Amazon themselves did not offer the goods or put them on sale. Amazon company themselves had not used David Off mark on its platform. Rather, the third party seller should have been held liable for trademark infringement. So Coty should have sued the third party seller and not Amazon. So I think again, we also have to look at it from the points where we have to now create laws for e-commerce platform, how they can prevent their work from prevent people from selling counterfeited goods. What are the storage policies they have? How are they verifying consent, permission, authorization from sellers, etc., etc. Now, for my business owners, entrepreneurs, startups, intellectual property is something that you should take very seriously. I mean, it's very important for your business. It also helps you come up with like business strategies. So, because it's an intangible asset in this digital era, it's key for creators and innovators who are contributing their quotas to the growth of an economy to take more seriously. Now we have international treaties such as the trade aspects of intellectual property rights, known as the TRIPS agreement, which provides protection and enforcement of intellectual property rights in member countries. So, if Nigeria is not if Nigeria is a member of the TRIPS agreement, so that means any other country where that are members or signatory to that agreement, we are required to also give them some sort of protection and enforcement of their intellectual property. They also help in providing effective and adequate protection of the intellectual property rights with a view of reducing distortion and impediment to international trade. Now, finally, in the event of a dispute that arises in the e-commerce space or platform, the company such as Amazon can create like its own dispute resolution mechanism. There are terms of use, refund policy, whatever it is. E-commerce websites must also be considered. Now, in this digital era, parties can opt for online dispute resolution mechanism, which is considered to be very fast and gaining popularity over the years. Settling out of court is also the best option because of the sensitivity of the dispute that may arise. However, going to court, just as how Coty and Amazon did, would set precedent for other future cases. Now, examples of common disputes would include misleading product information. So for this David hot water perfumer, was the product information misleading? Were they defective? Was it a counterfeit? Was it bought from an unsecured website? Did it involve like a cross-border dispute where the person bought it from, say, the United States or any of the EU countries and decided to import it into Nigeria? Especially in this era of electronic business environment, the main forms of ADR will include arbitration, mediation, negotiation processes that are effective in settling dispute out of court and in a manner that is less formal than litigation in court. Now we have the Chartered Institute of Arbitrators Nigeria branch. We also have the Institute of Chartered Mediators. We also have the Lagos Court of Arbitration. We also have the Lagos Chamber of Commerce. We also have Lagos Chamber of Commerce. Yeah. Lagos Chamber of International Commerce, something like that. I think LASIAC, that's what it's called. But one of the advantages of this form of dispute resolution, that's ADR, is that it's voluntary, it's cheaper, it's faster, it's private, it's a less formal, it involves a less formal procedure. Now, it turns out that Amazon has its own dispute resolution mechanism for buyers and merchants. You can check that out. It's called, just do a Google search for payamazon.com and it takes you straight to that's the buyer dispute resolution program. Just read it out. So I'll just do like a let's see. So where you buy, when does the Amazon Pay buyer dispute program apply? If you used Amazon Pay to purchase an item, so this is Amazon and trying to take responsibility in the event that a dispute arises, where you pay the merchant for the item or service but it did not arrive, where you receive the item but the item is materially different than the one the merchant had described, which happens a lot with Instagram sellers. You purchase something, what you ordered against what you got is not the same thing. What was in the picture is not what you got, and I'm sure a lot of people have fallen prey to this. So Amazon has its own pay disputes program which you can explore, which is a good thing, which I think and I hope that other e-commerce platform and also Instagram sellers would, start thinking of having like a online dispute resolution dispute program or plan to sort out issues like these. But nothing about what happens when. So Amazon defines what is called a materially different to be wrong version or edition, item conditions or details not as described. So which the hot water David Off perfume will include wrong item, missing parts, defective item, damaged item. I know I've used this platform before where I had ordered what's it called now? A crochet needle, and it was defective, and I had to make a complaint, and the person had to send another one again. So yeah, now finally, already existing and upcoming e-commerce platform in Nigeria should be more strategic when positioning in this digital economy by taking their intellectual property serious. So while we are excited about Amazon coming into the market, we also want to see them coming with their, new developments and policies that they've been taking out or exploring in other jurisdictions, and also give the Nigerian market a chance to showcase what we really have, and just be more proactive. So our Alaba brothers and sisters and Balogun market, the rest of them don't take advantage of it. But yeah, let me know if you found this episode insightful or interesting, what you learned, what you think I said wrong, what you want me to, correct, and I will do that. And so we have come to the end of today's episode. I hope you learned something. If there's anything I want you guys to take away, it's that when you buy a product from Amazon, know that you're not buying it directly from Amazon. You're buying from third-party sellers. So, like I stated, Amazon should have like a policy for third-party sellers who want to sell their products on their platform, especially Nigerian products on their platform. And if you're going to sell a product that is not yours, there should also be policies for that. The dispute resolution mechanism works. I know Amazon has like a pro bono service and all of that. So I'm looking forward to what Amazon has to offer, and I hope this is like a good opportunity for the Nigerian startups and business owners. But yeah, until the next IP series episode, thank you guys for listening to me talk and ramble about intellectual property. And yeah, bye for now, and see you in episode 71. Cheers, guys.